Okay, let's go on the record on cause number DC 196439, Olga Stepanchenko versus Tone Ray Hall, Betty Rose Horace, and Antoine Long. Counsel, make your appearances.
Brandon Steffi for the plaintiff, Your Honor.
Scott Archibald for defendant Long.
Jacqueline Chandler for non-party Allstate Insurance Company.
Okay, so we are here on, I believe, plaintiff's sixth motion to compel, and I've included the interrogatories and requests for production I believe that he is seeking in this particular motion. Oh, let me see. Did I share screen that? Can you guys see this okay?
Yes, ma'am.
Yes, sir, Your Honor. We're actually here on two motions. It's plaintiff's fifth motion to compel as well as plaintiff's sixth motion to compel. If I might.
Okay.
Then, Your Honor, before we get into that, I feel like I should have an opportunity to discuss the sanctions that were imposed against me personally, as my due process rights have been called into question, and I haven't had an opportunity to respond at any point. Also, we request a brief continuance in the fact that we haven't been able to schedule deposition of plaintiff's counsel, Mr. Brandon Steffi, until July 24th, I believe, despite attempts to schedule it before today's hearing.
Your Honor, I'd like to respond to that and just bring the court up to speed on the housekeeping matters. When we were here on 6/12, 4 weeks ago today, we were here on my motion for attorney's fees. At the conclusion of that hearing, Your Honor, Your Honor said, one, reset the fifth motion to compel for today. The court said, instructed the parties to brief the court on plenary power and jurisdiction because Mr. Archibald filed a motion to dismiss for lack of jurisdiction on the eve of the 6/12 hearing. Your Honor also instructed, allowed Mr. Archibald the option to do one of three things at the conclusion of the last hearing. One is take me on direct at the hearing. Two, offered him the opportunity to tender an expert rebuttal report to my motion for reasonable and necessary attorney's fees. Or three, offered him an opportunity to take a 30-minute deposition of me on strictly on the reasonableness and necessity of the attorney's fees. On Monday, 6/15, the very next business day, Your Honor, plaintiff did what the court instructed, which was file a brief on jurisdiction. On the same next business day, 6/15, my paralegal sent Mr. Archibald an email and offered 9 separate dates for my deposition in June and July, all of which predate today's hearing, and offered 7 more dates through the end of July. I offered 16 dates and times total in the calendar month from 6/15. Defendant never filed a brief on jurisdiction. The jurisdiction issue is not set for today, but I submit that it would be proper to deny defendant's motion to dismiss for lack of jurisdiction. And then 2, after multiple follow-up emails from my office, Mr. Archibald then noticed my deposition for July 23rd. On Wednesday of this week, Your Honor, he asked, his office emails me and says, hey, can we take your deposition in a couple hours? No, you cannot. He said, well, can we take it at some earlier time? And he said, yeah, you can take it next Thursday. And so to the extent that defendant Mr. Archibald has been deprived of an opportunity to take my deposition before today's hearing, that is simply demonstrably false, because I offered him 9 separate opportunities and followed up multiple times saying, hey, when do you want my deposition? So with that, since the last hearing, we've taken the deposition of defendant Long's primary alibi, Shanice Clark. That is now in the can. Ms. Clark says there's no explanation for Mr. Long's testimony that she picked him up sometime between 7 and 8 because it was well after 9, closer to the time of the hit and run collision made subject to this case when she picked him up. So that testimony is coming in at trial. Next Friday, we've got the deposition set of the eyewitness that identified the hit and run driver's make, model, and license plate of his car. He lives in Philadelphia. He'll be in Texas next Friday. We're going to take his deposition, and we're going to be ready to try this case on September 1st when this case is set for trial in the event we're permitted to try it. I get it, Your Honor, but we're until the court is modified our scheduling order. We're marching forward. We're ready to try it, which brings me to the two discovery motions that are before the court today. One is plaintiff's fifth motion to compel discovery from Antoine Long. The content or the substance of plaintiff's fifth motion to compel discovery was also the content of plaintiff's third and fourth motions, which the court ruled favorably.
Okay,
Plaintiff on.
Counsel.
Yes, sir.
I'm the judge, so I get to decide what order things go in. We're going to hear the sixth motion to compel first, which we have on the screen, and then we'll go back to the fifth motion to compel. So the sixth motion to compel is on the screen. What is the status of that? This was what was requested in the sixth motion to compel.
It is, Your Honor. Your Honor, I propounded this discovery on May the 12th. The responses were due 6/11. Before the Clark deposition on 6/15, I emailed Mr. Archibald, and here's what I wrote to him, Your Honor. I said, "Dear Mr. Archibald, I've looked, and so has Samantha and Nicholas in my office, and we cannot find Mr. Long's responses to plaintiff's second set of interrogatories and third request for production to Antoine Long, e-served 5/12/20 at 4:15 p.m. I attached it to the email, and then I say they were due June 11th. If previously served, please resend ASAP before our noon deposition of Ms. Clark, and we apologize in advance for any inconvenience, period. If not previously served, please respond without objections and produce responsive materials by close of business Monday, 6/29, or we'll seek appropriate relief with the court, period." And that's attached to my email. He never responded. Hence, I filed my motion on 6/30, the day after I told him I would. And so, he was served with the discovery. He emailed to confer with him. I served a motion, which he got notice of, and I served a notice of hearing, and I got nothing, Your Honor, until 10:24 a.m., 6 minutes before this hearing was scheduled to take place. He served some responses. I've not looked at them. I don't know what they are, whether they're sufficient or insufficient, because I haven't had time 6 minutes before this hearing. And so, yes, I think the proposed order that I've submitted to the court on plaintiff's sixth motion to compel tells him to proposes that he provide verified answers without objections to my interrogatories. The interrogatories seek credit card information to know his true whereabouts on the evening of the collision. And then we learned, despite his testimony, that he didn't go to a bar on the day of the collision. Through bank statements, we know he was. I had questions about that. And then also there was a credit card transaction with Whataburger on the day of the collision. I had questions about that. So I need answers verified without objection to that for interrogatories 20 through 22. My produced materials, Mr. Long uses a currency transfer app known as Zelle. He Zelles money to people frequently, both Julian Harrison, which is the subject of the next motion to compel. That's his alibi. That's who he was at the bar with immediately prior to the collision, as well as Shanice Clark. I need to know if I need to see his Zelle in Square Cash to see where he's spending money in the relevant time period. And then finally, Judge, yes, on this motion, I want sanctions. This is a severe and pervasive pattern of discovery abuse that continues. 4 times he's noticed with this discovery and doesn't even bother to respond until 6 minutes, excuse me, Your Honor, 6 minutes before the hearing is set. There is absolutely no excuse. And Your Honor, when we were here in November, it was the exact same fact pattern. Numerous continuances granted. I filed a motion, and then he didn't respond until after I filed the motion to compel the week of the hearing. And so here we are. Your Honor was frustrated in November. We've been back 6 times now. And Your Honor in November said this is bad. What's to preclude me from awarding $1 million in sanctions? Ultimately, after a couple more hearings, you did assess $10,000 in sanctions. But that's not getting the job done respectfully. Your Honor has been more than patient with this defendant, and the court's patience is just being abused. It's time to get their attention. And I submit, Your Honor, that anything less than 6 figures in sanctions is absolutely and reasonably necessary to curb this continued pattern of discovery abuses. I'm tired of making these same arguments every time we come down to the courthouse.
Mr. Archibald, actually, Mr. Steffi, So you see on the screen here, interrogatories 20 through 22 and 34 through 37.
Yes, sir.
These are the ones we're talking about in the 6 requests, correct?
Yes, sir. Yes, sir, they are, Your Honor.
So, Mr. Archibald, is that accurate, his statement that you didn't answer these until 6 minutes before the hearing?
Your Honor, that is accurate that we did respond to those requests prior to this hearing. Yes, within a few minutes, sure. But the requests themselves seek information that he already had, specifically with the DWQ, the Whataburger requests and the Tate's requests or interrogatories. I don't know why I struggled with that word. Both of those plaintiffs' counsel had sent DWQ questions to Whataburger and Tate's respectively. So he already has that information. The credit card information was already disclosed in his deposition that he testified to. And as far as the Square app and the Zelle activity, both of those are reflected in the bank statements that he had already, that we had already produced in one of our previous responses to discovery. So we have responded to them in so far as that we told them that we have already produced this information. And moreover, I don't have but one email from plaintiff's counsel and second email from somebody on his staff regarding the scheduling of the deposition. Certainly aren't 9 emails from him. And moreover, when we took the deposition of Shanice Clark, plaintiff's counsel, despite having claimed to have emailed me about the responses, never mentioned them at the deposition nor brought them up. We have responded to them, yes, Your Honor, and we have all of the information. He has all the information that he needs and that he requests, and it's all already been produced.
And Your Honor, I would just like to note that the certificate of service states that these discovery requests were served on all counsel of record. I never received them. I mean, I do represent a non-party, and I still think I'm in a counsel of record, and I never got a copy of it.
I don't know how you would be counsel of record if I mean, I understand if there's a hearing against Allstate, if there's any motions against Allstate, you would need to be noticed for, but I've never really seen the procedure that once you're representing a non-party on a particular motion, that you have to receive notice on everything else. And so I would disagree with that. But let me just kind of figure out. So there's a number of, as you can see on the screen, there's a number of, where does it talk about your request to get him to answer this particular discovery?
Yeah, if you'll go up to the top, right there, Your Honor, right there, Your Honor. That is on the morning of down a little bit, Your Honor.
Next page, Your Honor. Yeah, there you go.
Right there. That is the morning of the Shanice Clark dep. Obviously, I'm preparing for that dep, and I realized, hey, he did not respond to my discovery request. That's where I email him and say, I've looked, so is Samantha Nicholas in my office. And I lay it out. They were due June 11th. Either give them to me now before the Clark deposition or serve them Monday, or I'll file the motion. I had to file the motion. He never responded to that. And I know he got the email because we were emailing one another back and forth because he didn't have the Zoom link for the deposition, which I provided to him. And so he clearly got notice of the motion. He clearly got notice of the hearing. I mean, nothing until 4 minutes before today, Your Honor.
Mr. Archibald,
I have no idea.
So, Mr. Archibald, Mr. Steffi, I'm speaking now. So let me just make a comment real quick. Mr. Archibald, this is my sense of things. I'm not trying to criticize you or, usually when you've had cases in my court, there hasn't really been this type of issue. This is my sense of it, and this is not a ruling. This is just an attempt to maybe provide some constructive advice, which is, you've already been sanctioned in this case. Mr. Steffi is handling this case in a very aggressive way, which is his right. Most cases that you handle, I would bet, you may not be willing to admit this, is that most of the attorneys are not as aggressive as Mr. Steffi is. I know you probably have a very large caseload. If you know, my experience has been with y'all's lawyers that tends to happen. But it concerns me that, you know, after being sanctioned and all of the issues in this case that have happened, that you're still turning in discovery late. It's over a month late. You know, I understand in a lot of other cases, I used to do this type of law, you know, you'd kind of go along to get along and you'd try to work things out with the other side and give extensions and all that kind of stuff. That's not happening in this case with this particular case for whatever reason. And so it concerns me that yet again, you guys have not complied with your discovery obligations. And so I wonder if maybe, you know, maybe you could get some assistance on this case or something so that this kind of stuff, I don't like awarding sanctions. I wish we could get to the merits on this, but Mr. Archibald, this just keeps happening. And so I don't know what else to say other than you're making me do things I don't really want to do. But I feel like I have to because you're not complying with your obligations.
Thank you, Your Honor, for the advice and the guidance on it. I really appreciate it. And I certainly will take it to heart and moving forward, most definitely. It was an oversight in the fact that I didn't see them. Didn't, for whatever reason, it might have been lost in the flurry of everything having been filed. And insofar as the plaintiff's counsel didn't mention it on the deposition that we were at when I saw him face-to-face / camera-to-camera, or he didn't call me or anything like that. I absolutely hear Your Honor. No question that I will certainly heed that advice and continue to listen to it moving forward. Absolutely. And you're right.
Can I just say one other more direct advice, maybe? What I've seen this dynamic before. You're in-house counsel, right, for Allstate?
Yes, Your Honor.
I've seen this dynamic before where you have a very aggressive plaintiff's attorney in this type of situation. And what frequently happens, I'm not requiring this, but I am noting that this is what I have seen in the past, is that maybe this isn't a case that really is appropriate for in-house counsel. Maybe send it to somebody, you know, who has maybe more time and less cases to deal with this, because my impression is that you are continuing to drop the ball on this. And it may not even be really, I don't really think you're doing it deliberately. I just think you're in a very difficult situation here. You have a very aggressive attorney on the other side. You probably have, you don't have to tell me, but you know, hundreds of other cases, but not at least 100 other cases. And you're just, this stuff keeps happening again and again and again. And if you had, you know, somebody at the other, you know, on the plaintiff side that was in the same situation that you are, you guys usually would probably work things out, but that's not happening in this case. And so I don't want to keep sanctioning you, Mr. Archibald. I really don't. But I don't know what else to do. I mean, this is not the type of thing that you should be handling, in my opinion, not because you're not a very competent lawyer, but because my guess is you probably have too many other cases to deal with. I may be wrong. I'm not trying to criticize you, and I'm not trying to change. I'm not going to order you to do something. I've seen this dynamic, and the only way it seems to work out is to bring in outside counsel to try to kind of work all this stuff out. if you want to continue to represent the defendant in this case, which is your right and all states' right, and this stuff continues to happen, I'm going to continue to sanction you. And I don't really want to do that, but I don't know what else to do.
Again, I appreciate everything Your Honor is saying, and certainly going to take it to heart. Absolutely. And I have done and will do my best in the future to continue to represent my client zealously the best I can. And insofar as the plaintiff's counsel being aggressive or anything like that, it's certainly something.
You disagree that he's being aggressive?
I am not. I'm not going to go into anything like that, Your Honor. I'm just representing my client as best I can with the information that I've been given, and we've produced everything. I have no problem responding to the discovery responses. Further, we've already filed our response or served our responses already, like I said. But Your Honor, we're just working on everything we can, and plaintiff's counsel's inability to give me a call or send me any more email than the one he sent at 9:06 a.m. before a noon hearing or deposition, and then not mention it at the deposition. And further than that, the documents that he's requesting, without having received them, he's not going to be caught off guard. It's not going to present an unfair surprise and create any amount of any prejudice against him because he's already received all of the information that he sought.
Mr. Archibald, let me ask you a question, and you probably won't answer it, but I'll ask it anyway. Why does this keep happening?
With the discovery issues, is that the?
I mean, we're having this issue come up again and again and again on this case. I've never seen you have this kind of issue before. I mean, is it? I mean, and again, I'm trying to figure out a way. How do I get this to stop happening? And we sanctioned you once. Usually, in that situation, these types of issues stop happening after there's been a sanction, but they haven't stopped. And I would agree with you, Mr. Archibald, that frequently, if this was the very first thing that ever happened in this case, that I would say, okay, wish it hadn't happened, and kind of give you a break. But at this point, you're so far behind the 8 ball on this that even little things like this, you got to know that I'm going to sanction you for this again. And I don't understand why you would wait until 6 minutes before the hearing. As soon as you got this motion to compel, I would think that you would think, wow, this judge has already sanctioned me. I better jump on this. We dropped the ball. I need to get these responses in immediately and not wait until 6 minutes before the hearing. I mean, I don't understand why this is happening. Is it that you have too many other cases, or what is causing this to happen? Is it you don't like Mr. Steffi and so you don't want to respond? You're mad at the court? I mean, what is the issue here?
First of all, Your Honor, you're absolutely right. In typical cases and more common situations, I am able to work things out with other attorneys cordially and have that back and forth rapport with opposing counsel, no problem. I do my best to present myself in an approachable, amenable kind of guy and professionally, socially, in that context.
That's my impression of you as well.
I appreciate that, Your Honor. Thank you. And not pointing fingers or launching excuses more than it was simple oversight. We have had a backlog in our e-service inbox. It was backed up to like 800 unread messages at one point. So we've been dealing with that. We've addressed that situation. Maybe there was a delay in that. I can't speak to that specifically. All I know is that me and my staff, didn't see or realize that they had sent additional 4 or 7 requests, I believe, is the total number. And further, they've all been produced. All of those documents and all of the information has already been produced and disclosed.
Six minutes before this hearing, right?
No, in previous responses to discovery, Your Honor, and in the
Okay.
and so all of the information is on his desk and it's been sent over through prior proceedings and everything. And absolutely, this is most definitely the #1 case on my to-do list every single morning, Your Honor. And yeah, I do pay attention to it, but for some reason, these responses might have been lost in the flurry of motions and requests and hearings and everything like that. So it was a simple oversight. It wasn't an intentional deviance. It wasn't, we weren't avoiding anything specifically, it was simply an oversight.
Your Honor, may I ask, and I want to say this with all due respect. I mean, I've been to a couple of these hearings now, and it seems to me like maybe, Your Honor, you have an issue with staff counsel. And
I totally disagree with that, Ms. Chandler. I've dealt with Mr. Archibald in his office countless times. I'm really trying to help here. That Mr. Archibald, in the vast majority of cases, if you're dealing with, Ben Abbott's office or Everton Witherite or all the volume players, they usually do fine. I don't really have any problem with staff counsel, but
I apologize.
I think like I just said, I think the situation is Mr. Archibald, as he said, had 800 emails that didn't get responded to. They're really overwhelmed there. And I am concerned, if you have kind of both sides are overwhelmed, they're more likely to work things out. Mr. Steffi, I've never had a case, I don't believe, with Mr. Steffi before. Maybe I have, and I just don't remember. But Mr. Steffi is handling this in a very, I'm not saying inappropriate, but very aggressive way. He's not kind of cutting any breaks to the other side, and he's
not picking up the phone and calling him. Which, in any case I had, I would have expected somebody to pick up the phone and call me. I'm not saying that he should have had to do that, but I can just tell you, if I'm truly asking for discovery responses and I'm not getting it, I pick up the phone and say, "Hey, what are you doing?"
Miss Chandler, how many emails are in your email? I don't remember what you said. E-file. What did you say that was backed up, Mr. Archibald?
It's our firm's designated e-service inbox. Every single correspondence that goes to any attorney in our office goes to the same inbox. So,
how backed up is your firm on your e-service inbox, Ms. Chandler?
I have no idea, but I'm sure there is some backup because I work in a large firm, much larger than the staff counsel.
What firm do you work for?
Thompson Co.
Yeah, Thompson
Co. So
but I guess my question, Thompson Co. We never, and I imagine, I know I have a lot of interns who've worked at Thompson Co. They tend to have a lot lower caseload than my only point is that I feel bad for Mr. Archibald. He's overwhelmed, it seems to me, is my impression. And I don't want to keep doing this. I don't think that, but by the same token, he has to comply with the rules. He has to comply with the law. And I just want him to do that. He can keep doing this, but if this keeps happening, I'm going to have to keep sanctioning him, and this is going to keep happening. And I don't want to do that. What usually happens, and I'm not requiring this, but usually happens once staff counsel, because they let's say Mr. Archibald had a case and Payne Mitchell was on the other side, and they're very aggressive, very good lawyers, and they started filing tons of discovery requests, and they wanted to go all over the country and take depositions, and they had experts. Frequently, those types of cases would be transferred to a firm like Thompson Co. I'm really trying to help Mr. Archibald. Isn't that I have a problem with them? But I feel like the usual methods I have for convincing attorneys, hey, look, you guys need to take this seriously, and you're really messing up, are not working. And so I'm really trying to give him a way out. I don't want it to appear at all. I've had hundreds of cases with this firm, and 95% of them, they tend to go to trial more than I wish, but 95% of them, 98% of them, 99% of them, this kind of stuff doesn't happen, but it's happening in this case, and I'm trying to help Mr. Archibald as opposed to just continuing sanctioning him. And that's all I'm trying to do.
I understand it, and I say, and I mean, I really do mean it with all due respect, but it's just every time I've been on one of these hearings, I'm just hearing comments about Allstate and Allstate Staff Counsel, and it just I just wanted to just plain out ask you if there was a problem there, and you just with that group particularly, just
no, not at all. I just want, but I don't think that. I just don't know that this is the right case for Mr. Archibald, given kind of what's happened. But if he wants, if he wants to, or Allstate wants to, or his client wants to keep him on his counsel, I'm not going to forbid that. I just am trying to say, look, Mr. Archibald, you keep getting, this keeps happening. What are we going to do here? I'm running out of options. I don't want to keep sanctioning him, but.
And I do think that the rules with respect to certificate of conference require, my understanding was it requires a phone call, and it requires two separate days. I think if a phone call would have happened, and I'm not excusing any delay, but I think if a phone call would have happened, we wouldn't even be discussing this. And
but
so,
Shannon, let me ask you, and if at Thompson Co., you had already been sanctioned once on a case, or one of the attorneys there had been sanctioned once on a case, and you knew that you did not want that to happen again, would you be hyper careful in that case and make sure that you followed everything, you got everything out in time, or would you kind of just go along to get along?
No, I would be hyper careful, and I think that Mr. Archibald has been hyper careful.
I just don't think so.
Well, and that's why I wanted to point out to you at the beginning, I didn't get a copy of this stuff. And I mean, I would have expected to get a phone call. So I agree. And he's
Ms. Chandler, why aren't you counsel of record on this? Why wouldn't you?
Allstate.
Okay.
And
I guess that is that a conflict if you couldn't represent both, I guess?
Their interests are aligned, so it's not a conflict. But
no, I mean, just like why couldn't you represent the defendant in this case? Is there a conflict for you representing? Probably no. There is to represent defendant and Allstate. I'm not saying a conflict for you representing Allstate, but could you represent both? I don't.
I could represent both.
Yeah, I don't think you could either. But I don't. I'm not. I don't want to award six-figure sanctions against Mr. Archibald. I
don't think it's appropriate.
But I do feel like I need to. I don't know what else to do.
Yeah. So briefly, Your Honor, this is an ongoing issue in that plaintiffs' counsel continues to just file motions and requests. They haven't necessarily pointed to any conduct on my part or the office's part. Again, this was it was buried in all of those motions that have been filed. We sat across the table, quote unquote, in our deposition, and there hasn't been an opportunity. There haven't been any attempts other than a last second email mentioning it, and he didn't even refer to that email, nor did he refer to the responses. Had I not responded to the email, I mean, if I sent something like that to somebody, I would ask them in the deposition, on the phone, give them a call. I mean, I've got several other attorneys that have handled the cases more aggressively and have no problem working things out with them and talking to them and coming to an agreement. But this situation, it hasn't been the case, and that's just kind of where we're at. But absolutely, Your Honor, I am hyper aware of it, most definitely. It's just this one might have.
When was this motion to compel filed?
6:30. It was filed June 30th. 10 days ago. You got notice of it. And Your Honor, if I could just respond, his assertion that I already have this information is demonstrably false. Okay. And that's also a continuing pattern of demonstrably false statements to the court. We've got interrogatory number 20. I don't have the account numbers I don't have in writing all the credit card and debit card information. With respect to number 21, I don't know what he purchased at Whataburger, and I do not know the time. I do not know what he purchased. I don't know the time that he was purchased at Tate's because the timestamps are ambiguous. I want to know what time he was there, and I need to hear it from Antoine Long, and I'm entitled to get that information. With respect to the apps that he uses to transfer cash, that's going to provide additional information about when and where he was on the day of this collision. We've got a party in council that is sponsoring demonstrably false testimony. We still do not know his true whereabouts on the evening and at the time. I need to know where he was in the minutes and the hours immediately prior to this 920 hit and run collision where the make, model, and his car was identified. All we know is that he was out celebrating his birthday with friends. His girlfriend believes he was with Julian Harrell or Harrison, which we'll get to in the next motion, but she doesn't know if he was at Tate's, doesn't know what bars he was at or what he was doing.
That's irrelevant, though, to these discovery issues. Whether or not the truthfulness of a party, that doesn't matter to this discovery. That's an issue for trial. If you want to impeach the defendant in this case, I mean, by all means, that's your right. But whether or not you think that somebody's not telling the truth, that is irrelevant to this discovery issue. And you've sent depositions on written questions to both Whataburger and to Chase Bank. So you are getting it straight from the source, right?
And counsel has produced a receipt with Antoine's banking information from Tate's in Shanice Clark's deposition. So any indication that he doesn't have any idea as to where he was or what he was doing, or the fact that he's going to be prejudiced by not responding to these questions is in fact demonstrably false on his own part, and that
it's ambiguous because there's two different times, Mr. Archibald, and you know that. That's why I'm entitled to get the information from Mr. Long. And to the extent, Your Honor,
all of this is kind of irrelevant because you didn't file responses, as I understand it, to these discovery within 30 days, correct? So you waived your objections.
There are no objections.
Okay. Well,
I've not reviewed the responses, Your Honor. They were served 6 minutes before. And to the extent that it got lost in the shuffle, it didn't get lost in the shuffle, not once, not twice, not 3 times, but 4 times, Judge. You've got the meet and convert, you've got the service, you've got the meet and convert email, you've got the motion, you've got the notice. Here we are today. 4 times it gets lost in a case where the counsel should be hypersensitive to timeliness of production because he has been previously sanctioned for a failure to timely respond. Your Honor, I would ask that the court rule and that we move on to my 5th motion.
We're actually beginning to run out of time anyway, but I'm going to go ahead and grant the motion to compel, I guess.
6-figure sanctions is not even allowed under the rules. The rule under Rule 215 states that you can award reasonable cost or attorney's fees. There's no way that the plaintiff counsel is going to sit here and tell us that he spent 6 figures in filing his 6th motion to compel.
Sanctions I seek are to punish and deter this type of conduct. I've not sought. This is not about reasonableness of attorney's fees. That's the subject of a separate pending motion. Mr. Archibald has a right to depose me on, but this is to punish and deter for the abuse of the discovery process.
Not under Rule 215.
Under 215, it has to be compensatory or remedial, not designed to punish or arbitrary. It has to be related to expenses and attorney's fees, and that's Ford Motor Company versus Tyson, 943 Southwest 2nd Edition, 527.
Did you file a response to this motion to compel?
This 6th one,
Yes, you did.
Yeah, we did, Your Honor.
There is a response that came through at 10:34, 4 minutes after this hearing was scheduled to take place. I certainly have not read it, and I ask that it be struck. It's untimely. You don't file an answer to a motion after the hearing has already begun. That's what they've done. I haven't read it, and it needs to be struck. It's tiring, and it's
Okay.
repeated
So
violations.
I'm going to go ahead and grant the motion to compel. I'm going to grant the motion for sanctions. I'm going to award $15,000 in sanctions to be paid by September 1st, which I think is the trial setting, correct?
September 1st, yes, Your Honor.
And I'm willing to reconsider this if I can see that these issues are being dealt with. I just don't understand how you cannot answer discovery on time, how you would wait until 6 minutes before. I mean, it's just, given the history of this case, I don't understand this. This is not how this is normally done, but we can keep going down this route again and again. The court has no desire to do that. We just want this to stop. But so the fifth, in 20 seconds or less, what's going on with the fifth request? I didn't know that was even set today. So
20 seconds or less, Your Honor. He violated the third and fourth motions. I still do not have phone records from Antoine Long, despite the court ordering that he compelled him to produce them, because he says they're not reasonably available to him. He's on his dad's phone account. He lives with his father. Dad, as you're watching TV at night, can you please give me my phone records? I don't have that. I don't have any emails. I don't have any social media, despite court orders to do so, Your Honor. I need a spoliation instruction in connection with the emails and the social media, and I need the phone records that the court's already ordered him to produce. All he has to do is ask his dad for the records, and I get them. The other thing that's on the, can I please finish my 20 seconds, Ms. Chandler? The other thing that I do not have, Your Honor, is he's been ordered to provide an address, a phone number, and email address for Julian Harrell. That was in the third motion to compel. I still do not have it. The phone number does not work. I don't have a complete address, and I don't have an email address. I need this person's deposition. I need to subpoena him for trial, because that is the person that Long says he was with on the day of the collision. That's who Shanice Clark, the girlfriend, says that he was with on the day of collision. We've done a lot of effort trying to contact this person, cannot get a hold of him. Mr. Long zells this person money all the time in $20 and $40 increments. I wonder what that's for. But anyway, at the end of the day, Mr. Long and Mr. Harrison have a very close relationship. He was at his apartment on the day of the collision. And to say that you can't give me an apartment number, you can't give me a phone number, you can't give me an email address is nonsense, especially when you're under a court order to do so. He's violated the court order. I need the information on Julian Harrison, and I need the phone records, and I need a spoliation instruction on the social media and the email. That's what the third motion to compel is about. That's been pending for months now.
And on that, Your Honor, we have produced everything my client has. The phone number, that's the phone number he has for his friend. That's the one he gave me. That's all he's got for that. He doesn't know the unit numbers. He's not required to create evidence that he does not know or otherwise have access to.
I don't disagree with that.
He's
What about the social media?
Social media.
I'm sorry, I didn't hear. What did you say, Your Honor?
I said I don't disagree with that.
The social media, there were no posts from the day of the accident. There were no emails from the day of the accident. That's what we included in our responses. After a diligent search, no responsive documents to this request were located in our possession, custody, or control. And my client does not have access to his phone records. He does not live with his father. He lives with his mother. He doesn't have access to the phone records because he's not a listed an authorized user on it. He doesn't have access to those phone records. He does not have possession. He does not have superior custody of them. He has no access to them because he's not on the phone records. We've given every ounce of information that we have that is not only related to these requests, but that he has at all. We've gone above and beyond the requests specifically, saying that we produced all of the bank documents that suggest anything that would be in Zelle, and any indication or assumption that plaintiff's counsel is trying to make in $20, $40 increments is purely inappropriate, and it's suggesting things that are far outside the scope of discovery. And I have the information. I've given every ounce of information that my client has and that has given me, and there's nothing else. I have talked to my client ad nauseum, trying to get all of these documents and information that is relevant and required to be produced in compliance with the court order. And I've given everything that we've got, everything that my client has.
Did I previously order just emails and social media from the day of the accident, or was it a longer period of time?
I believe it was just the day of the accident, Your Honor. I can get there in two seconds, Your Honor.
And I've confirmed multiple times with my client that there are no social media posts, there are no emails, there are nothing from the day of the accident.
Let me ask a different question. So Mr. Steffi said that he provided you 9 dates for him to be deposed. Did you depose him during any of those 9 dates prior to today?
I did not get that email that was sent to my assistant, so I was not copied on that email specifically. We got one scheduled, and there's been a little bit of a turnover in my office, and I lost my scheduling assistant. So my new assistant's been being caught up to speed, and she's not as familiar with this case as my previous one was. So there's been a little bit of catch up to do with her as far as the importance and the order in which things need to happen. And I'm working on it. And that's why when I finally caught wind of the fact that it was scheduled the 24th, that I said, hey, we need to have this before this hearing so we could address the attorney fees issue. At that point, I was like, hey, listen, it's a 30-minute deposition. Absolutely not 1 second longer. And I'm wholly capable of complying with that. That is not going to be an issue at all. And plaintiff's counsel suggested before that he's wasted Saturdays in preparation for this, but he hasn't had 30 minutes set aside to take a deposition about one very specific topic. I mean, I'm more than willing and frequently do work late into the evening, into the early morning hours. Like that is no problem for me. And plaintiff's counsel has been incapable of providing any opportunity for me to do that.
False, Your Honor. On June 26th, my paralegal, again, for the second time, followed up and copied Mr. Archibald, said I wanted to follow up with this, and offered June 30th, July 1st, 2nd, and 8th. That's 4 more dates before today's hearing. We offered 9 initially and then 7 more after. I offered 16 dates the next business day after Your Honor offered him the opportunity to take my deposition. So to state that he didn't, that I've been uncooperative is simply disingenuous, and it's false. He had 9 dates on the next day. I gave him, we followed up a week later, and he still had 4 more dates that he could have taken it before today. And he didn't show any interest in taking it before today until Wednesday. And no, I can't stop and give a deposition on an hour's notice. No attorney can or should be expected to. So to suggest that I've been non-cooperative is just wrong, Judge.
And Mr. Archibald, I mean, this is, again, another instance, and again, I'm not trying to give you a hard time. I understand the dynamics of this type of situation, but, you know, he gave you 9 dates. The standard is 3, and your scheduling assistant dropped the ball because you guys are just overwhelmed, it seems like, with cases, which is, you know, that's, I'm not, it's just, it's, you have to understand that this kind of stuff isn't.
Yeah, I absolutely, I understand, Your Honor, absolutely. And there were only 1, 2, 4 dates provided that were before this hearing. The 30th, the 1st.
That was the second time, Your Honor.
And that was the first email that I received. I did just find that email, searching both the attorney and his assistant. The 30th, I was unavailable. The 1st, I was unavailable. And the 2nd, I was out of the office on PTO. So I wasn't available on those 3 dates. The 8th would have been perfectly fine with me because we tried to get it on the 8th. And at that point, he said, no, not in an hour's notice, even though
2 days ago, Judge.
I was unavailable on the 30th, the 1st, or the 2nd. I was available on the 8th. And
but he'd given your office 9 dates before that, and none of those. I don't know of any of those specifically, Your Honor. I don't know of any of the prior dates because I wasn't included in that email. I really am trying to bend over backwards to be fair to you, Mr. Archibald. I really am. I don't know how much more clearly I can say that I feel bad. I really do feel bad for you, that I think you're in a very difficult situation. But at this point, I'm going to just, you had your chance to take the deposition. You didn't do it. 9 dates is more than fair. So.
Your Honor, I think that there at least needs to be some, I mean, have you produced these 9 emails? Which I, again, wasn't copied
Never
on.
9
I think
emails,
this
Ms.
is
Chandler. There was 9
relevant to me.
offer dates.
It
Okay,
was
well,
9 dates offered. not
9 dates
emails.
offered, which again, I mean, I do think I should be included on this part because Allstate has an interest in this issue with
But
respect to the initial
Allstate's not a
sanctions.
party.
I know,
Sanctions are against Allstate.
but the check that plaintiff's counsel cashed was sent over with specific instructions that said it was being paid on behalf of the sanctions entered against Allstate. And
That's
it
right.
said,
But
don't
you
cash
said
those
you
until.
pay Mr. Archibald sanctions.
No, it did not, because it was sent before Mr. Archibald was sanctioned. So that is absolutely not true. That check was sent over before that hearing. And
Okay.
then, so I think we have an
you
interest.
asked, Ms. Chandler, you asked a question, and it's a good question, which is there was an email where 9 dates were provided. Is that I'm looking at the wrong
No,
motion,
sir.
aren't I?
It's not attached to the motion, Judge, because there was nothing set for today's hearing with respect to attorney's fees. I can forward that email to you right now if Your Honor would like. I can forward it to Ms. Pinson if you'll give me just a second, Judge.
Well, I mean, I think that there should be an opportunity to take a look at it and then do a little investigation about what is going on. I mean, if for nothing else, it may just help move this case forward, going in a forward basis, if we can figure out what is the issue with communications here.
Well, I think it's clear what the issue is, but okay.
I would like to see the evidence and then.
Or can you share screen it? Here, let me stop sharing. We've gone way over on this hearing.
I can forward it right now.
Why don't we do this? Mr. Steffi and Mr. Archibald and Ms. Chandler, why don't you guys confer about this? See if you can't work out, an issue, work out when you want to go ahead and what you want to do about this deposition.
It's
if it really is, Mr. Steffi, don't interrupt me, please.
Yes, sir. Yes, sir.
If it really is a situation, Ms. Chandler, that Mr. Archibald's office was provided 9 dates for this deposition and they didn't take a deposition except for the last time where they tried to do it on 1 hour's notice, I'm going to say that they waived it. If that's what happened, I don't know that it is, but if that's what happened, I'm going to find that they waived their opportunity to take the deposition. If that's what happened.
I would just like to see.
If that's not what happened.
Your Honor,
I want you to provide Mr. Steffi, Ms. Chandler, a copy of that email as well, so she can see. Maybe Ms. Chandler can do something to maybe deal with the situation, help deal with the situation. And why don't we reconvene on Monday at 3 o'clock and see if we can't, between now and then, you guys can work everything out. Does that work for y'all's schedule?
I am available at 3 o'clock. Yes, Your Honor.
Mr. Steffi?
I'm trying to get there. Yes, sir. The 13th, I will be available at 3 o'clock, Your Honor.
Ms. Chandler, does that work for you?
Yes, Your Honor.
Mr. Steffi, make sure you provide Ms. Chandler and Mr. Archibald a copy of that email before then.
You'll have it in 2 minutes, Your Honor. Would you like me to copy the court?
No, I want you to bring it to the next hearing and share screen it.
I will, Your Honor. Thank you, Your Honor.
Thank you, guys.
Are these all your interns?
Yeah, these are. I do have another case here, but yeah, we have about 12. So,
okay.
But I would love to introduce them. there's a long history of anyway, but they're great. They're 11 of them are from SMU and one is from William and Washington Lee. So
we've had lots of people from your interns at your court that have come to work at the firm and who have clerked there.
Yep, great. It's a great firm, and I hope that. Anyway, I wish this whole issue could get worked out. So, but I got another hearing I got to get to. So let's get to the next one. And I'll see you guys on Monday. Okay.
Thank you, Your Honor.
Your Honor.
All right. Bye, guys.
Bye.
Off the record, Tony. So let's deal with the next hearing. And I'll say this, that I've had an opportunity to read everything. So you don't really have to go into a whole lot of depth on this. Do you guys want a record? This is a motion for partial summary judgment, correct? Are y'all there?
Yes, Your Honor. David Kasab is here on behalf of Amir Skandari.
Morning, Your Honor. Jason Hopkins on behalf of the plaintiff.
Okay, so we're here on a motion for partial summary judgment, correct?
That's right, Your Honor.
Okay. So what I'd like you to do to start your argument is just give a brief procedural history of the motion to dismiss briefly and this motion for partial summary judgment, how they interrelate. You don't really need to go into a whole lot of facts about this. Hit the highlights of your arguments. We don't have a whole lot of time, unfortunately. And did you say you did want a record or no record?
I don't, Your Honor.
I don't need a record, Your Honor.
Let's proceed, guys.
Thank you, Your Honor. The court's right. We were in here last Monday on a TCPA motion that Mr. Kasab filed. The court has that under advisement, and under the rules, the ruling is due, I believe, by July 29th. As it relates to this motion, the same prima facie case that supports denial of Mr. Kasab's TCPA motion also supports a judgment in favor of the plaintiff. The facts here, Judge, are straightforward. We have a settlement agreement that says don't say nasty things about Kevin Casey. And then we've got Mr. Kasab's lawsuit that says nasty things about Kevin Casey that was filed on behalf of Amir Skandari. So we're asking the court to do two things. To, number one, declare that lawsuit constitutes a breach of the settlement agreement's non-disparagement clause. And number two, enjoin Mr. Skandari from continuing similar conduct in the future. Now, the evidence that we've submitted in support of that is straightforward, Judge. It's the settlement agreement that says don't say nasty things and the lawsuit that says nasty things. Mr. Kasab raises 8 arguments by my count about why that is not sufficient to support the entry of summary judgment. The first one that he says, first one he raises is that the requested judgment, i.e. that there is a breach of the agreement by virtue of the Houston lawsuit, does not conform to the pleadings. But Your Honor, it absolutely does. What we asked for in the petition is the same thing I'm asking the court for now, i.e. to declare that Amir Skandari breached the settlement agreement when he filed that lawsuit down in Houston. The second argument is one that Mr. Kasab made before the court the last time we were in here. And he says, well, the settlement agreement doesn't prohibit a party from truthfully testifying in court or pursuant to a subpoena. The problem for Mr. Kasab here is the same as it was on the TCPA motion, and that is that there is no testimony and there is no subpoena. Pleadings aren't evidence, they aren't testimony, and there just isn't a subpoena here. So I think that's a sort of red herring. The third argument, this is a new one to me, Judge. It's on page 8 of Mr. Kasab's response. He says that the statements made in the Harris County lawsuit were, quote, filed privately with the Harris County District Clerk and are not public statements. There's not a case that supports that because it's not true. The open course provision of the Texas Constitution says that all of this stuff is a matter of public record. I don't know how an argument can be made that says when I file a lawsuit in the public record that is somehow not a public statement. And there's a reason that there's no case cited in support of that. Mr. Kasab does cite a case that says a statement made in a deposition is not public, but we're not talking about that. That doesn't have any applicability here. His fourth attack, Your Honor, is that we have insufficient evidence. He says Mr. Casey needs to submit an affidavit that details at length this and that. But the point of this case, Your Honor, is that it is so straightforward. There are only two pieces of evidence that you need to resolve this case. Number one is the agreement that says don't say nasty things. And the second is Mr. Kasab's lawsuit that says nasty things. The fifth argument that Mr. Kasab raises on page 13 of his response is that the statements were not disparaging because they were true, and truth is an absolute defense to defamation claims. There are a lot of problems here. Unpack a couple of them. The first is that truth is a defense and defense has not been pleaded. But more importantly, truth is not a defense to a declaratory judgment action on a contract, which is what this is. This is not a tort case, despite Mr. Kasab's attempts to turn it into one so he can get under the judicial statements privilege, which we'll get to in a second. This is a contract case. There is not a provision in the agreement that says don't say false things that are nasty. There is a provision in the agreement that says don't say anything that's nasty. So again, the statements aren't true, but it doesn't matter whether they are or not, because this is not a disparagement case. Truth is not a defense to a contract action. And even if it were, it hadn't been pleaded. Mr. Kasab then says, well, you're not entitled to an injunction because you haven't established irreparable harm. But we've cited the court to two cases, one out of Dallas and one out of Houston, that say that reputational harm is irreparable harm. And the reputational harm is set forth squarely in Mr. Kasab's lawsuit down in Houston. It maligns, criticizes, and denigrates Mr. Casey for page after page. All of that is, as a matter of law, reputational harm. And that supports the entry of a permanent injunction. The seventh argument Mr. Kasab makes is that there's no adequate remedy at law. He says, well, we could just sue for damage. The problem here, Your Honor, is we've got to stop Mr. Mareskandari.
So let me ask this, and this is something I'm pretty concerned about, which is you're trying to handle a temporary injunction through a summary judgment. Is that right?
No, Your Honor, it's a request for a permanent injunction.
Permanent injunction through a summary judgment. Excuse me. I've never seen anyone do that. Is that even allowed to do a permanent injunction through a summary judgment? I've never seen anyone do that.
I've done it, Your Honor. I can get the court some briefing on that. But I mean, yeah, I mean, let
me ask Mr. Kasab, do you agree that not whether or not I should grant it, but that summary judgment is permissible on a request for permanent injunction?
Your Honor, I think that, it could be if there was evidence that conclusively established the entitlement to each element. But, obviously here, as pointed out in the response, there's zero evidence, so it's inappropriate.
Okay. So you're not objecting to the fact that he's trying to deal with this through a summary judgment. It's just you don't think there's enough evidence.
Yeah, Your Honor, I think procedurally it's fine because it's a claim, and I think that if he establishes each element of the claim through conclusive evidence, then I think that he would be entitled to summary judgment just like any other claim. So we don't have a problem with, procedurally moving on summary judgment on that claim. It's just a matter of whether or not he's supported it.
All right, as long as you're okay with it, it's kind of an interesting issue. But if you're okay with that particular point, then I won't make you guys brief it. But kind of speak now for however hold your peace, because
yeah, Your Honor. I mean, I don't recall seeing a case on that precise issue one way or the other. The injunction cases that counsel cites, they were all trials where testimony was presented on the elements of an injunction. so, they have no application here, but, I'm with the court. I haven't seen any case like that, but, I'm not in a position one way or the other to dispute it right now.
The reason I raise this issue, because I know there's case law out there that says, now it may not be good case law, but I know I've read it before, where if you have a temporary injunction, even if it's unopposed, you still have to produce evidence in support of it, and usually in the form of live testimony. It just seems counterintuitive that you could do this in a summary judgment. I'm not saying it's wrong, I don't know, but it seems counterintuitive that you'd be able to do that in a, you know what I'm saying, by summary judgment and not have live testimony. But I guess a permanent injunction is different than a temporary injunction. But if it's not a concern to you, it's not a concern to me. It seems somewhat counterintuitive.
Your Honor, I hear the court's concern. Your Honor, I hear the court's concern, and Mr. Kassab's argument that he's making in a slightly different context is that we need a more fulsome declaration. And I hear the court saying, typically in these cases, you've got live testimony. The difference here, again, Your Honor, is the case is so straightforward. We've got a settlement agreement that says don't do X, and then we've got a lawsuit that does exactly X. So I don't know what additional evidence I would put on before the court other than the imminent irreparable harm that is established by Mr. Kassab's lawsuit. But if the court is concerned about that, the easy way to fix it is to grant the motion as to the declaration, and then Mr. Casey and I will show up before the court either virtually or in person, and we'll give the court all the testimony that Mr. Kassab says in his response that he wants to hear. The last thing I'd like to talk about with the court is this judicial proceedings privilege, and I won't belabor it because I know we talked about it last time. That privilege says in a tort case, you can't get sued for defamation because you went to the court and you said something in a filing. The problem here is that there is not a single Texas case, and I've looked, that allows the judicial proceedings privilege to be used to justify a breach of contract. In other words, Mr. Kassab is saying that his client gets to say nasty things about Mr. Casey as long as he does it in front of a court. In other words, that settlement agreement is meaningless as long as a judge is the one that sees the breach of contract. There's a reason there's not a case that says that. The result would be absurd. He cannot breach this contract anywhere in the world except before the court. That's not the law, Your Honor. So for those reasons, we'd ask the court to grant this motion and enter the injunction, or if the court is so inclined, to set a hearing on an application for injunction.
Response?
Yes, Your Honor. Thank you. So first off, the requested judgment does not conform to the pleadings with regard to the declaratory judgment. If the court looks at the pleadings on paragraph 11, they're requesting a declaration that, quote, the public filing of a disparaging statement constitutes a breach of the settlement agreement, end quote. What he's requesting on summary judgment is, quote, a declaration that any public statement means any public statement, and that Mir-Skandari's Houston lawsuit contains public statements that violate the settlement agreement's non-disparagement clause, end quote. Those are two separate requests for declaratory relief. And we've cited the case law on the motion that, of course, the summary judgment must be supported by the pleadings, and the final judgment must conform to the pleadings. And so with regard to the declaration that Casey's actually requesting in his pleadings, there's no dispute that the settlement agreement provides that the public filing of disparaging statements constitutes a breach of the settlement agreement, if the exception in the provision that I'll talk about a little later does not apply. So, but that's not what he moved for summary judgment on. He's wanting a different declaration. And so we think that with regard to the declaratory relief claim, it doesn't conform to the pleadings, and therefore it does not, that point should be disregarded and summary judgment should be denied. The declaration also will not resolve any justiciable controversy because, as
Mr. Kassab, can I ask you a question? Can you share screen both the petition and then what he's asking for in the summary judgment and explain how there's a difference?
Yes, sir. This will be my first time doing that, so let me go ahead and see if I can successfully do that. I did quote the two declarations on page 5 of my motion, or I'm sorry, my response. And those were the only requested declaratory relief. But let me see if I can pull up his pleadings and then,
You'll need to share screen it.
yeah. Okay, I got the petition pulled up. I'm pulling up the summary judgment, and then I will share everything here.
You see on the bottom where it says share screen?
I see, yes, there we go. Okay.
Did it?
I have two screens here, so let me, I think you're on the right one there. So, can you see the petition that I have pulled up right now, Your Honor?
No, you're not share screening it.
Oh, let me try this.
There you go.
Okay. So this is the petition,
Okay.
and here's the request for declaratory judgment. And he says, this controversy will be resolved by a declaration that the public filing of disparaging statements constitutes a breach of the settlement agreement.
Okay. And then what is he asking in the summary judgment?
And then on summary judgment, says this court should declare that any public statement means any public statement, and that Mirskandari's Houston lawsuit contains public statements that violate the settlement agreement non-disparagement clause.
That seems to be pretty much exactly what his petition says, isn't it?
Well, Your Honor, no, the petition states that the controversy will be resolved by a declaration that the public filing of disparaging statements constitutes a breach of the settlement agreement, not that Mirskandari in fact violated the settlement agreement by doing what he did and pleading in a lawsuit that was filed against his attorney the facts of the underlying case.
It seems to kind of be a distinction without a difference, but okay. What else do you have?
Okay, Your Honor. Just rearrange here. With regard to it kind of piggybacks. The second point is that the declaration will not resolve any judicial controversy because the declaration that he actually seeks is that the public filing of the disparaging statements constitutes a breach of the settlement agreement. Of course, we don't dispute this because the settlement agreement itself says neither party shall directly or indirectly publish, issue, or communicate with any public statement that maligns, criticizes, denigrates, or disparages the other party. But the real controversy, like I stated, is whether or not, in fact, Mirskandari breached the settlement agreement by making the statements in a private pleading that he filed in the lawsuit against his attorneys. We don't think that he breached the settlement agreement because there is that exception that the provision will not apply to prohibit any party from truthfully testifying in any court proceeding or pursuant to other legal process. You know, the settlement agreement doesn't define those terms, so the court has to look to their ordinary meaning. And we think that when read together, the public statement must be a declaration or a mark of facts or opinion that exposed to general view or accessible to general view and all members of the community. And we think that paragraph 6 of the settlement provision contemplated posting something on the internet. And in fact, paragraph 6 even instructs that the offending party should remove any disparaging statement that is, quote, posted on the internet to the extent it is in their control. And so we think that based upon that language, it was the intent of the parties that the disparagement provision applied to those statements that were posted online and on the internet. With regard to the claims for injunctive relief, again, Your Honor, it's a traditional summary judgment motion. Casey had a duty to establish each element by competent summary judgment evidence. And, you know, the court is well aware of the elements of a permanent injunction, but it requires demonstration of a wrongful act, imminent harm, irreparable injury, and no adequate remedy at law. He hasn't established those elements with any evidence, no testimony from himself, especially with regard to the irreparable injury element. I mean, he's admitted that he submitted no evidence. So we think summary judgment with regard to those, the injunction claim is improper. Your Honor, he keeps saying this is a breach of contract case, but he hasn't pled a breach of contract claim. I mean, the only claim he sought is an declaratory relief, an injunction alleging defamation type damages that he'll suffer irreparable harm because of the statements. And we think that because of that, the claims do in fact fall under the judicial proceedings privilege. And the case law that we cited there in our response state that it really doesn't matter, you know, what you call the claim, that the court must consider the entire communications in their context, and they must extend the privilege to any statement that bears some relation to an existing or proposed judicial proceeding and resolve all doubts in favor of applying the privilege. And the Houston Court of Appeals stated, First District in 1998, that although most cases addressing the judicial communications privilege involve claims of libel or slander, Texas courts have consistently applied the privilege to claims arising out of communications made in the course of judicial proceedings, regardless of the label placed on them. And, you know, the case law, the string of case law that we cited in the response stated that Texas courts universally agree that a party cannot avoid the circumvention of the policy just by pleading it as a different type of claim, and that the privilege should be extended beyond defamation when the essence of the claim is damages that flow from communications made in the course of a judicial proceeding, and they seek defamation related type damages. And we think that that's what Mir Skandari, the gist of his claims, that's what he's seeking. And so we think that even if he had met his burden with regard to the claims, the declaratory judgment claim and the injunction claims, that the judicial proceedings privilege applies, and that the court should deny summary judgment, Your Honor.
All right, response.
Thank you, Your Honor. Just real briefly, the argument that the settlement agreement is limited to internet communication is contrary to the plain language. It says, neither party shall directly or indirectly publish, issue, or communicate any public statement that maligns, criticizes, denigrates, or disparages the other party, period. That's what it says. There's no limitation to internet communication. As to Mr. Kassab likes to say that I'm asking for defamation type damage. He said it just now, and he said it in his response. The problem is that's not in the petition, Judge. This isn't a damages case for the straightforward reason that these reputational damages that Mr. Kassab's lawsuit has caused are difficult to quantify. I knew that if I came in with a breach of contract case and I said damages, his TCPA motion would have said, you don't have sufficient evidence of damages, and I'd have to have an expert at the TCPA stage proving up reputational damages. We get twisted off in the weeds on that, and then the court probably have to grant it because I wouldn't have been able to collect the evidence necessary to support damages. So there are no defamation type damages sought in this case. This case seeks two things: a declaration that Mr. Kassab's lawsuit filed on behalf of Amir Mareskandari breaches that provision of the agreement, and an injunction to stop Amir Mareskandari from doing it again. He already agreed not to do this, Your Honor, and he won't live up to his agreement. So the only remedy
So,
I've got
so the
left,
only damages you're really seeking are attorney's fees under the Declaratory Judgment Act.
that's right, Your Honor. We are not seeking fees. What we want him to do is stop, and he won't stop on his own. So we need the court's help to make him stop.
Okay, so we will get a decision to you guys by the end of the month. Any other questions? Anything else you guys wanted to say before I let you go?
No, Your Honor. Appreciate the court's time.
Your Honor, you were very nice to that previous attorney. I'll tell you that about the hearings. But, I've seen some judges that would have just had a heyday